A very good afternoon, everyone present here. I, Huma Khan, Assistant Professor on behalf of Faculty of Law, Integral University, welcomes you all to this virtual platform in the third module of Faculty Development Program 2024 on integration of intellectual property rights principle into teaching, research, and professional activities for today's session on the topic Digital Rights Management, Research, and Academic Works. And today we have Dr. Abhishek Kumar Tiwari sir with us to discuss this topic. Dr. Abhishek Kumar Tiwari sir is currently working as an Associate Professor of Law in the Faculty of Law, University of Lucknow. He has 14 years of teaching experience. He has done his PhD in law from Lucknow University, and the topic of the research work is environmental aspect of genetically modified crops, a critical study in the light of international environmental guidelines on national law. Sir has completed LLB from Banaras Hindu University. He has done his master's in intellectual property rights from Dr. Ram Manohar Lohia, National Law University. Sir has also lots of publication works, one book, 18 research papers, and a book review, and also published more than 10 articles on books and many journals. He has also underwent the National Human Rights Training Program in 2008 with the Dr. Ram Manohar Lohia, National Law University, Lucknow, sponsored by National Human Rights Commission, New Delhi. Also worked on the project working of the Domestic Violence Act 2005 with special reference to Lucknow. So now, without wasting much time, I would like to invite the sir for today's session. Sir, the house is open for you. Welcome you to the session.
Thank you, Dr. Huma. I thank the organizers for inviting me to express my views on this book. I think this is very relevant. The topic which has been given to me, that is digital rights management. First of all, we have to understand what is the digital rights management system. Digital rights management, in short DRM, is the use of technology to control and manage access to copyrighted material. Another DRM meaning is taking control of digital content away from the person who possesses it and handling it through a computer program. DRM aims to protect the copyright holders' rights and prevent content from unauthorized distribution and modifications. So, digital rights management is very where we are living global and acting on so increasingly important digital content states through and sites media companies protect from the cybersecurity challenges. All organizations face protect in and enhance
Disconnect हो गया. There is some technical glitch. Please wait for some time.
right now audible? So we were discussing DRM, that DRM is increasingly important as digital content spreads through peer-to-peer file exchange, torrent sites, and online piracy. It helps entertainment and media companies protect themselves from the cyber security challenges that all organizers face, such as protecting customer data, ensuring and demonstrating compliance, enhancing operational efficiency, and preventing downtime. DRM enables authors, musicians, movie makers, and other content creators to clarify and control what people can and cannot do with their content. It also allows them to protect their copyrighted material, safeguard the creative and financial investments they put into their work, and make it impossible for their media to be stolen or shared illegally. For example, they can prevent users from accessing specific assets. So they can avoid any legal issues that could come from unauthorized uses. This is crucial to protecting copyrighted and intellectual property rights. So now next question starts, that how DRM works, how digital rights management is done. The unauthorized distribution, sharing, and modification of digital content are covered by copyright laws. But monitoring the internet to prevent illegal activity is a challenging task. DRM addresses this by putting barriers to place to prevent digital content for being stolen. DRM typically involves the use of codes that prohibit content copying and limit the number of devices a product can be accessed from. Content creators can also use applications to restrict what users can do with their material, or encrypt digital media, which can then only be accessed by anyone with the decryption key. This enables content creators and copyright holders to, first of all, prevent, restrict users from editing, sharing, saving, forwarding, printing, or taking screenshots or screen grabs of their content or products. Second, it's to set expiry dates on media, which prevents access to users beyond that date or limits the number to times they can access it. Limit media access to specific devices, internet protocol, IP addresses, or locations, such as limiting content to people in the living in the United States or living in the India, etc. Watermark documents and images to assert ownership and identity of content. So watermarks can be used, images can be used so that the ownership of the content may be exclusively depicted. Digital rights management cases, if we talk about, DRM is used across a wide range of digital content, from entertainment media like books, music, and videos, to database subscription, software programs, and sensitive business data. Using DRM to protect this media enables content creators and copyright holders to prevent people from making changes to their work using it for unintended purposes. Here are a few common examples of DRM practices. For example, digital music. You know that Spotify is a particular company. Spotify leverages blockchain technology to enable the payment of artists through cryptocurrency. The music streaming company brought a startup media chain to help it identify songs that were played and the right artist to pay using digital rights management system. Apple iTunes can be another example. Apple's iTunes store user DRM to limit how many devices customers can use to listen to songs. Audio files that users download from iTunes includes data about their purchase and uses of songs. This prevents the files from being accessed on unauthorized devices. Apple also protects to content in its iBooks store with Fair Play technology, which ensures books can only be read on iOS devices. Likewise, the third example can be the Microsoft software. Anyone that downloads Microsoft software such as Windows or Office programs has to accept the company's user license and enter a key before they can install it. Microsoft also has DRM technology called PlayReady, which secures the distribution of content over a network and prevent unauthorized uses of its software. Sensitive documents can be the other example where many organizations use DRM technology to safeguard business critical documents or sensitive information, such as confidential employee data, business plans, and contracts. DRM enables organizations to track who has viewed the files. To track who has viewed the files, control access to these files, and manage how people can use the files. It also prevents files from being altered, duplicated, saved, or printed. Fifth can be by the way of regulation compliance. Digital right management system is crucial for helping organizations comply with data protection regulations. For example, it enables healthcare organizations to meet the requirements of the Health Insurance Portability and Accountability Act and assist all organizations in meeting the needs of the requirements of California Consumers Privacy Act and European Union's General Data Protection Regulations are there. Now, if we want to understand what are the benefits of digital rights management, so we can look into the benefits as aside from protecting copyright holders and content creators from acts of piracy, DRM provides several other key benefits. What other key benefits are? Number one, copyright education. Many people pay little attention to the copyright details of the content they own. DRM help organizations clearly communicate what customers which in educate users about how intellectual property work. Second is ownership. DRM is crucial helping authors and writers protecting their work. Use technology to retain ownership of their content and prevent anyone else from altering or rebranding it as their own. So this is also used by scientists who want to protect their findings and inventions. Third benefit is protecting income, creating, filming, and editing documentaries, movies, and other videos cost creators money in the hope of selling their content for a profit. If that content gets leaked or shared without their consent, they can lose money. So DRM enables content creators to ensure only paying users can access their videos. Like OTT platforms, only those members who are subscribing OTT platforms can access OTT. Fourth is ensuring appropriate content access. DRM restricts content to specific audiences and limit content to intended audiences. For example, content intending for people over the age of 18 will be restricted to adults who can verify their age. So ensuring appropriate content access. By this, the people of delicate age can be restricted from accessing any content which is not suitable for them. Fifth benefit is file privacy. DRM helps organizations secure their sensitive files and ensure they remain private. Unauthorized users from accessing or reading confidential or sensitive information. DRM softwares or the different technology come in the form of either software or hardware solutions. Both options allow content creators to prevent deliberate piracy and unintended unauthorized uses. Digital assets management platform allow organizations to control access to any copyrighted material. They do this in several ways, including can be which creators holders the digital content copyright and license Um, I think this is due to the internet connectivity. We were discussing digital asset management platforms allow organizations to control copyright material. This in several ways, including watermark, graphics can be placed on assets, which enable creators or copyright holders to track unauthorized uses. The watermark stays connected to a file when the digital content is copied, manipulated, or transformed into another format. So, by this watermark, the identity of the data is embedded. Second is metadata. Digital assets have metadata that enables their copyright and licensing information to be captured and monitored. This is critical to tracking licensing details of stock audio files, photos, and video to prevent unauthorized uses. Third is embedded codes. Contents Content owners can also use embedded codes that control how and where this media is published online. This is useful if the license of an image changes or expires because it enables the license to be changed or updated where the related embedded code has been posted online. This process is also referred to as create once, publish everywhere, which is crucial to a successful strategy. Fourth can be license agreement. License can protect their content and software by requiring users to read and agree to the end user's license. In end user's license agreement, it is agreed the first time user access a website, shares files, or downloads content. Thus, organizations protect their assets from unauthorized users. Issue was highlighted by the Sony Pictures hack, which saw the leak of employee data plus unreleased movies, plans, and scripts for future films. The release content can have a major impact on companies' bottom line and reputation, which make the use of DRM crucial to protecting their content. Second is network visibility. Many entertainment and media companies use cutting edge technology to improve customer experience. The growth in cloud, mobile, and Internet of Things devices not only makes managing the corporate network more complex, but also expands organizations' attack surface. This is exacerbated as they deploy more security products to protect their infrastructure, which results in security silos and diminished visibility and increase inefficiency and risk. Protecting investment. Entertainment and media offering require large upfront investment before they make a profit. Organizations need to prioritize security spending to protect this investment and minimize their risk. Managing customer experience, digital innovation is heavily focused on customer experiences. As evidenced by the rapid rise of streaming services, online gaming, and virtual reality, these services rely on secure and reliable cloud based solutions and mobile networks, which can be negatively affected by even a brief interruptions in connectivity. It is crucial and organizations to deliver on customer demand to protect their reputation and prevent financial loss. So connectivity is a major issue. If particular company is not able to provide connectivity, that will also lead to its disrepute. Another issue which is related to our discussion is protecting customer data. Increasingly stringent data and piracy regulations are especially important to major media and entertainment companies. These organizations often possess the personal and financial data of millions of people, and it is vital that the data remains safeguarded. They must also ensure they comply with the growing regulations landscape without redeploying staff focused on delivering strategic initiatives. Now, if we take particularly the challenges before the digital management technologies, and if we want to discuss these challenges, then we have to discuss the important legislations. In USA, there is Digital Millennium Copyright Act. So I will address the Digital Millennium Copyright Act, a law designed to provide DRM technologies with an extra layer of legal protection and discuss the implications of the extra layer of legal protections. DRM technologies, as we know, that include the technology that can be used to impose direct functionality restrictions on digital content. And a simple example is encryption technology that restricts access to database to those individuals or devices having the appropriate password key. But DRM technologies also can impose more complex restrictions. For example, they can be designed to prevent user from taking particular actions with the data or regulate the manner in which they take those actions. Thus, DRM technologies can prevent or limit the act of copying, extracting some of the data, or transferring some of the data to a different document or to a different device, such as another computer, or personal digital assistant. Second, DRM technologies can be used to effectuate click wrap. Click wrap is a contractual restriction. It is possible to use combination of direct functionality restrictions and click wrap contract restrictions to produce a fairly broad range of regulations of the behavior of database user. Click wrap restrictions might be used to implement a pay-per-use scheme that allows metered access and possibly some copying for a fractional fee. Alternatively, they might be used to impose narrower restrictions such as prohibition against disclosure of the data to the public or against use of data for a commercial purpose or against use of the data to reverse engineer a computer program. One recent case brought by the New York State Attorney General involved a click wrap contract restriction prohibiting the publication of critical review of software package. We'll discuss this case later on. Finally, DRM technologies can be designed to effectuate self-help, such as disabling access to the database or to some portion of the database of the system, detects attempt to engage in some sort of impermissible actions or detects unauthorized files residing on the user's computer. For example, if a copyright holder can detect unauthorized MP3 files somewhere on an individual system, it might use that fact to disable access to lawful subscription service. A lot of presence around the potential capabilities of self-help technologies. Not heard anything to suggest that these capabilities are being implemented in the scientific database, but certainly they are subject to elsewhere in the market BI. Implication of DRM technology for scientific research are there. What are some implications of these technologies for for information? First of all, functionality restrictions have some obvious implications for access to and use of unprotected, uncopyrightable information. Authentication restrictions can inhibit initial access to the information, allowing access based on device or domain or on permission of a valid subscriber identification. In cases involving research, this can generate aided transaction cost because so in cases involving collaborative research, this can generate aided transactions cost because researchers will have to make sure that everyone with whom they want to collaborate is coming from an authorized device, domain, or subscriber identification. If the DRM restrictions prevent accepting, excerpting, or extracting of the data, this will hinder research efforts that require extraction and manipulation. So these are certain uh, hardships in using DRM techniques, digital right management systems, and in other way we can say that this is inconvenience to the other users. In cases in those involving collaborative research, this can generate added transactions, added costs, because everyone has to access by authorized device, domain, subscriber identification, etc. So if the DRM restrictions prevent accepting or extracting of the data, this will hinder research efforts that require extraction and manipulation. If the DRM software or hardware is designed to require proprietary file formats for any data that are extracted, these restrictions may cause other kinds of problems. Papers intended for publication may be subject to limits imposed by the demands of the DRM system. Direct functionality restrictions also raise the risk of loss of access to data, because if we specifically talk about the restrictions for researcher, while doing research and especially in the field of academia, we are required to learn from authenticated sources. We are also permitted to use those sources, some excerpt from those sources. But what is required? Proper reference and credit in the way of footnotes is required. So that is also cumbersome. If DRMs are used in a very complicated way, if DRM restrictions prevent excerpting, extractions of the data, this will hinder research. Papers intended for publication may be subjected to limits imposed by the demands of DRM system, and direct functionality restrictions also raise the risk of loss of access to data, either because a subscription has expired or because the system has invoked self-help functionality That system may invoke self-help functionality to disable itself. By the self-help, the data from the article may be removed. If the expiry time has been mentioned on it, it may be expired. So this can create certain kind of problems. So loss of access in turn raises the possibility of damage to other files or programs that may reside on the researcher's system. Pay-per-use provisions and other click wrap restrictions also have some important long-term implications for research. Long-term implications. First, the pricing of some of these subscriptions can represent a significant cost. It can be significantly costly. In addition, the use of click wraps to restrict subsequent use and disclosure raises concerns about secrecy and freedom to publish. It is worth separately highlighting some of the potential effects of DRM technologies on libraries. Because in academics, libraries play very important role. The topic which I am dealing is use of DRM in research and academia. So libraries are backbone of research and academia. How can DRM can affect academia? So libraries will have the headache of managing all the authentication restrictions. They also will need to worry about loss of access to back issues of journals and databases when subscription expires. All the databases, all the journals, they have subscription, and after the expiry of subscription, they will not be available in the library. That is not how their print and microfiche collections have worked. And if it is fairly significant, concerns for obvious reasons. Libraries also need to be connected about loss of control over formats for archival storage, search, and retrieval of data. Search tools have to be able to interact with file structure of the database. They are designed to search. If the file structure are proprietary for regions to the imposition of DRM, then a search engine capable of interacting with the proprietary wrapper may also be considered a proprietary tool. This in turn raises questions about who will be permitted to develop those tools and what restrictions will be placed on their use. All of these issues are critical to libraries. And the library's mission of facilitating access to information by their user communities will be at stake. So in the light of the benefits, in the light of hardships, we are required to discuss about the existing law, we are talking about the position of American domain. So on this field, digital rights management, America has enacted a law, that is Digital Millennium Copyright Act of 1998, which has four main types of provision. This enactment have four main type of provisions. First, the DMCA, Digital Millennium Copyright Act, in short DMCA, as I'm telling DRM, Digital Rights Management. It prohibits circumvention of a technological measure that effectively control access to protected work. It prohibits circumvention of technological measures that effectively control access to a protected work. Note what this provision does not say. It does not say thou shall not circumvent a technological measure that effectively protects the right of the copyright owner in a protected work, such as the right to copy the protected work. The right to copy the protected work. Some circumvention of such copy control measure is not prohibited. The statute prohibit only circumvention of access control measures, but considers the different ways that a DRM system can be designed to work. Access to database may be provided via click wrap system that treats every act of opening up the database and using it as a separate act of access to the database. If so, then arguably the anti-circumvention provisions applies to each instance of use, even by an unauthorized user. So, if the DRM measures require the application of some sort of password, or every time one wants to use the database, one cannot circumvent that password for any reason, because it is a technological measure that effectively controls access to protected work. The second important thread of provisions is the DMCA contains what I will call anti-device provision. These provisions are somewhat more complex. They prohibit manufacturing, distributing, or trafficking in a technology that meets any one of three criteria. And when I talk my views, so they are based on Julie Cohen, as she has written, The Challenges of Digital Rights Management Technology. I based my talks on her research. So, second, DRM technologies can be used to these implications. Under the DMCA, it contains anti-device provisions as per the author. These provisions are somewhat more complex. She has explained that they prohibit manufacturing, distributing, or trafficking in a technology that meets any one of three criteria. Number one, it is primarily designed. It is primarily designed or produced for circumvention of a technologically protection measure. Second, it has only limited commercially significant purpose or user other than to circumvent. Or third, it has been knowingly marketed for use in circumvention. The anti-device provisions apply both to device for circumventing access control measures and to devices circumventing DRM measures that effectively protect rights of the copyright owner, such as the right to copy. Think back to the wording of anti-circumvention provisions. One is not allowed to circumvent to unlawfully gain access to a work. A theory, at least, nothing prohibits circumvention to get around a technology that protects a right of copyright owner. But where are users going to get the tools that would allow them to undertake lawful acts of circumvention? These are the questions. The anti-device provisions exist to ensure that such tools cannot be offered on the market. Technically, the anti-device provisions protect only DRM measures that are applied to copyrighted works. Some types of databases may not be covered by the copyright, but database providers still may apply DRM measures to these databases. And if they use DRM standards that are also widely used for copyrighted works, then the anti-device provisions anti-device provisions probably will prevent the sale of circumvention technology anyway. Third important provision of the DMCA include some exceptions to the anti-circumvention and anti-device provisions. An exception for non-profit libraries allows some circumvention of access control technologies. That is of our use. That is broadly related to research and libraries. An exemption for non-profit libraries allows some circumvention of access control technologies, but only to decide whether or not to make an acquisition of a work, not subsequent to the acquisition decision. Libraries are not exempted from anti-device prohibitions, so they cannot develop circumvention tool in any way. Any case, they cannot tool circumvention tool. They cannot develop. As one might predict, there is a reasonably broad exemption for law enforcement. Reasonably broad exemption for law enforcement, intelligence agencies, and the like to circumvent DRM measures and to develop circumvention tools. Another exception allows circumvention and the development of circumvention tools for the purpose of reverse engineering. Computer software to create interoperable software. Interoperable software. Subject to some conditions. Number one, the copy of the software must have been lawfully obtained. The copy of software must be lawfully obtained. Second, the interoperability information must not previously have been readily available. Second, the interoperability information must not previously have been readily available. Third, the circumvention and tools are for the sole purpose of reverse engineering. And the fourth, the information and tools can be shared with other people only for that purpose. The DMCA also includes an exception for good faith encryption research. This is also related to academia. Good faith encryption research with some fairly stringent conditions on who can qualify. Who can qualify? The research has to satisfy a criterion of necessity. And the researcher must have made a good faith effort to obtain authorization from the copyright owner to undertake the circumvention. There are manner limits on the dissemination of information and circumvention tools that are similar to ones that apply to the reverse engineering exceptions. Reverse engineering exceptions. The researcher can disseminate the information. Researcher can disseminate the information gained from the circumvention only in a manner that is calculated to further the research and not in a manner likely to facilitate infringement. So here, the knowledge, the information, the data obtained through circumvention shall be used only in a manner that is calculated to further the research. That is calculated to further the research. For promoting the research, for the use of research, not for violating and infringing the rights. If it is not in that manner, it likely to facilitate infringement. So the good faith encryption research exception also includes some credentialing requirements for the researchers themselves. One thing that helps the court to determine whether someone qualifies to claim exemption is whether that person is engaged in a legitimate course of training, study, or research in computer science, and therefore, by necessary implications, not just some hacker somewhere Finally, the information that is gained from the research must be shared with the copyright owner. There is also an exception of computer security testing. An exception of computer security testing, which is subject to conditions similar to those that apply reverse engineering and good faith encryption research exceptions. The circumvention must satisfy the sole purpose and criteria that there are manner limitations on subsequent dissemination of the information gained. Finally, the DMCA contains some provisions identifying other rights that it supposedly does not affect. These include limitations or defenses to copyright infringement, such as fair use, rights of free speech or the press, and principles governing vicarious or contributory liability for the design of electronics, computing, or telecommunication equipments. These are these were the summary of the important provisions of DMCA. With that, it also required to discuss some cases on DMCA litigations. What do all these provisions actually mean and what are their implications for the use of public domain and scientific and technical data and for collaborative research? Three high profile cases shed some light on these questions. The first case is of United States Universal City Studios versus Remedies, is often referred to as the DECSS case. In this case, a 15-year-old Norwegian John Johansson developed a technology called DECSS, which circumvents the content scrambling system, CSS, content scrambling system, that protects the movies encoded on DVDs. According to his later court testimony, he did this to create a Linux based DVD player that is an open source DVD player. The initial decryption program, however, was a Windows based program because Johansson was working from a Windows based DVD player. Johansson shared these programs to DECSS fairly widely. One of the organizations that ended up with DECSS was a hacker magazine based in New York City called 2600.com, which put the program on its website 2600.com, and its principals were promptly sued by members of Motion Pictures Association of America and were permanently enjoined from posting the program. Permanently enjoined from posting the program by Motion Pictures Association of America. The court also enjoined defendants from knowingly providing links to any other website that provides DECSS. Both parts of that injunction were upheld on appeal. So this was the first case. The second, this created the major aspect of digital rights management system, and that is if someone creates such player and is leaving it on the open platform, if somebody is using for that copyright violations, then the responsibility. So the website owner has been held liable. In the second case, that involved Professor Ed Felton, who took the SDMI challenge. In short, and the full form of that is Strategic Digital Music Initiative. SDMI is Strategic Digital Music Initiative. Strategic Digital Music Initiative, SDMI, was a project to develop a secure technology for protecting digital music files. The Recording Industry Association of America, RIAA, challenged researchers to try and crack the prototype SDMI technology. Professor Felton and his team at Princeton succeeded. Rather than submit their results confidentially to the technology provider and claim a cash prize, Felton decided to publish them and arranged to present the paper initially at a computer security conference. So challenge was given by the company to crack SDMI. The professor accepted the challenge with his team and he cracked it. But in place of communicating his cracking to the company, he presented it as a paper. He tried to present it as a paper. Professor Felton decided to publish them and arranged to present the paper initially at a computer security conference. The RIAA, Recording Industry Association of America, notified the conference organizers and Princeton University's legal counsel of the possibility of a lawsuit if the paper was presented. RIA notified Princeton University and the organizers of the conference that if he will present that paper, then lawsuit will be filed against the university and the professor. Professor Felton withdrew the paper from the conference and publicized the circumstances, generating considerable uproar within the scientific community. withdrawal, with, withdraw, but he publicized the circumstances, generating the paper from the conference and publicized the circumstances, generating considerable uproar within the scientific community. The RIAA, Recording Industry Association of America, immediately issued a press release stating that it did not intend to sue. As a great uproar, hue and cry was there, so RIAA immediately issued a press release stating that it did not intend to sue. Professor Felton filed a declaratory judgment suit against the RIAA and the technology provider, challenging the lawfulness of what he claimed was threatened suit for or possible prosecutions for violation of DMCA, digital this digital rights. He also arranged to present the paper at a different conference and did so. So at one stage, he was threatened by the association, recording association. He has to withdraw the paper, and he withdrew at that time. He withdrew it, but later on, he presented it in certain other conference. He filed a declaratory suit also that challenging the possible prosecution in future. Subsequently, the court granted the RIAA's motions to dismiss the suit. It ruled that there was no credible threat of suit or prosecution after the other party claimed intent to sue. They disclaimed. They said that we will not sue him. So the case was disposed of, dismissed on the basis of their statement. And the other case, the other important case is United States versus LCOM. United States versus LCOM. It was the first criminal prosecution under DMCA. First criminal prosecution under DMCA. It involved a Moscow-based software firm, LCOM, which developed a technology that disabled certain DRM features of Adobe ebook reader software. So in the case of United States versus LCOM, in which first criminal prosecution under DMCA has been done, it involved a Moscow-based software firm, LCOM, which developed a technology that disabled certain DRM features of Adobe's ebook reader software so that one could, for example, make a copy of an ebook to back it up or to transfer it to different device. To back it up or transfer it to different device. LCOM distributed its software via a website that was accessible in the United States. Shortly thereafter, one of its leading programs, Dmitry Scalaro came to the United States to attend a software conference. Dmitry Scalaro was arrested at the airport, extradited to the Northern District of California, and arraigned under the criminal provisions or arrested under the criminal provisions of the DMCA. He subsequently cut a deal securing his release in exchange for agreement to testify in the government's prosecution of Elcom, his employer. So Dimitri was the employee of Elcom. When he came to America for participating in a conference, he was arrested. Later on, he agreed to be government testi- testify the government's prosecution of Elcom, his employer. The court denied defense motions to dismiss the case on constitutional grounds. The court denied motions to dismiss the cases on constitutional grounds and also on the ground that court lacked personal jurisdiction over Elcom for actions taken in Russia. Ultimately, however, the jury acquitted Elcom of all charges, finding that even if Elcom had violated US law, it had not done so willfully. Now, question arises, what do these cases tell us? At first, they tell us some things about the general scope of DMCA's prohibitions. In the case of DECSS case, defendants argued that the CSS for DVDs could not possibly be the kind of technological measure protected by the institute because it was so easy to hack. Specifically, they noted that the institute refer only to effective technological measures and argued that CSS was relatively ineffective. It probably will not surprise you that the court ruled this cannot possibly be what the DMCA means, because otherwise the institute would not protect very much. To be protected under DMCA, an effective technological measures does not have to be hack proof. This though means that given the broad language of the institute, virtually anything could qualify that given the broad language of the institute. Virtually anything could qualify as the kind of technological measures that is protected by the DMCA. The institute protects any measures that require the application of authorized information or an authorized process to gain access to the work, or that prevents or restricts the exercise of a right of the copyright owner. A simple password requirement that one could get around quite easily might qualify the DMCA. Therefore, potentially covers many kinds of DRM gateways. Also, under the heading of general scope, the cases establish that one can be liable for knowingly linking to another site. We are discussing case of Remedies knowledge is intended. Here it is important and parallel the requirement for liability. Here is it is based on notice. Knowledge can be established based on notice, and that the copyright industries are fairly diligent about sending out such notices, even if the server hosting or circumvention tool is located outside the United States. Then a copyright owner can use notices to ensure the description of links that might lead US based users to the circumvention tool. A final thing that we know about the general scope of DMCA is prosecutors can rely on it to arrest people from other countries when they get off the plane in the United States, and that courts will uphold personal jurisdictions cover over those arrested. Elcom suggests, however, that the harshness of this rule may be mitigated in practice by the difficulty of establishing willfulness directed specifically towards US laws. Second, the cases tell us something about the relationship of DMCA to the doctrine of fair use and contributory copyright infringement. Doctrine of fair use and contributory copyright infringement, both of which are designed to avoid overlay a broad infringement liability that might threaten other important public policies. The courts have concluded that there is no general fair use defense available under the DMCA. No general fair use defense available under DMCA. As already noted, the DMCA does have a provision stating that defenses to copyright infringement, including fair use, are not affected. The courts have reasoned, however, that a cause of action under the DMCA is not a cause of action for copyright infringement. Instead, it is separate and distinct cause of action for circumventing DRM measures or for manufacturing or distributing a circumventing technology. Nowhere in the DMCA did US Congress provided a fair use defense to either of those cause of action. Therefore, the DMCA contains to no open-ended safety value valve comparable to the fair use doctrine, designed to avoid overlay a broad anti-circumvention liability. Contributory copyright infringement is a doctrine that protects technology providers in certain circumstances. One can sue a technology provider for providing technology that facilitates copyright infringement. So contributory copyright infringement doctrine. This doctrine, under this doctrine, one can sue a technology provider for providing a technology that facilitates copyright infringement. So there should be measures of copyright upholding. So if it is itself providing copyright infringement, then it can be said to be contributory liable. But there will be no liability if the technology is capable of substantial non-infringing use. Substantial non-infringing use is there, so there cannot be any liability fixed on it. In the case of Sony Betamax case, the Supreme Court held that BCR was capable of many substantial non-infringing uses. Therefore, Sony could not be held liable simply because people could also use BCRs to engage in unlawful copying. We remember BCRs by Sony. They were used to engage unlawful copying. In contrast, the courts have read DMCA's anti-device provisions to say that there is no substantial non-infringing use. No substantial non-infringing use. Defense to a charge of manufacturing or distributing circumvention tools. Recall that anti-device provisions cover technologies that are primarily designed for circumvention, that have only limited commercially significant use other than to circumvent, or that are knowingly marketed for circumvention. Those are very different standards than whether technology has substantial non-infringing uses. Therefore, the court in the TS-6 case concluded that the contributory infringement doctrine has been overruled by Congress in the circumvention context to the extent of any inconsistency with the new law, that is DMCA. Thirdly, the first wave of DMCA litigation highlight the narrowness of the reverse engineering and encryption research exceptions. Narrowness of the reverse engineering and encryption research exceptions. The defendants in the TS-6 case argued that they could claim both of those exceptions. They could claim both of those exceptions. They noted that TS-6 was developed in the course of reverse engineering and for encryption research intended to produce a Linux compatible DVD player. The court rejected this argument on the ground that the defendants, a third parties not involved in the reverse engineering process, lacked standing to invoke either exceptions. So here, who could invoke this provision? The person who developed it, not the company which associated it. The clear import of the court's ruling is that disseminating information to the general public to solicit participation in a process of reverse engineering or encryption research will not shield the recipients of that information. Fourth, the courts have the courts have uniformly rejected constitutional challenges to the DMCA. In all three cases, the challengers argued that the statute was facially overbroad and therefore violated the First Amendment because it regulated for more speech in the form of computer code than was necessary to achieve the legitimate purpose of preventing infringement. In pre-Emerdes and Elcom, the courts reasoned that defendants lacked standing to argue overbreadth on the basis that others might use the disputed technologies to make fair use of copyrighted work. We are well versed about the fair use provisions under the Copyright Act. So anything which is for research purposes, anything which is for study purposes, that is, and which is not affecting the party financially adverse, it is not making profit, then it is considered as fair use. This issue remains unresolved and it is difficult to predict how the courts might rule on it. The Felton case, however, suggests a way for courts to avoid doing so. The only party who clearly was making a fair use, Felton, had a surmount the initial threshold of demonstrating that there was some reasonable likelihood of suit, that any chilling effect on Felton's speech existed once the RIAA issued its press release stating that it would not sue. That seems inconsistent with the some of the First Amendment case law about chilling effects for the present. However, it seems that in DMCA cases, courts will require more than a threat hastily retracted following bad publicity to demonstrate a chilling effect. To a very real extent, this ruling insulates the copyright industries from suit and the DMCA from constitutional threat by bona fide fair use. Bona fide fair use is always established and that is permitted in many laws. Suppose Copyright Act or it may be DMCA. The Murdes and Elcom courts also rejected arguments that under Article 1 of the Constitution, Congress lacked the power to enact the DMCA in the first place. So DMCA can be enacted. It is not ultra vires. Again, they reasoned that since defendant themselves did not seem to making any fair use of protected works. Sorry. There was no need to consider whether there would be constitutional problems if the statute prevented others from making fair uses. The courts also opined that fair use would save the statute in any event. By this, Fair uses that one can make without direct copying. For example, one can point a video camera at a DVD playing on one's computer screen or directly transcribe by hand the contents of protected ebook. The courts opined that the fair use privilege does not give users the right to make the best technological kind of fair use that they could possibly want to make. So fair use provisions cannot be diluted to that extent. If anybody filming by camera or taking screenshots of ebook, it will not fall under the fair use. Finally, the early DMCA cases shed some light on the ways that the DMCA is likely to be deployed in the future. Whatever differences between these three cases, the bottom line is that all of these cases have involved the anti-device provisions. They have all involved people who were charged with, or in Felton's case, threatened with charges for creating technologies that could be used by other people to circumvent access control or copy control measures. Access control or copy control measures. The main purpose of the institute seems to be making sure that actual or potential circumvention tools do not get created or disseminated. In holding that technology providers have no standing to invoke possible fair use by other to support constitutional defenses. Court reinforces this message and ensures that would be fair users who are not technologically savvy are out of luck. Even though users technically retain circumvention privileges in cases involving copy controls as opposed to access control, they have to be able to develop the tools themselves. If that is not developed by themselves, then the case may be something other. What are the implications of the DRM or DMCA regime? Digital right management and DMCA regimes we can see very first few DMCA cases hold up what are the long-term implications of DRM plus the DMCA for research and innovation. There can be about four important issues. First, the new regime of DRM controls backed by law intensifies the impediments to information sharing and collaboration previously discussed. We have discussed it that DRM controls backed by law intensifies the impediments to information sharing and collaboration. It is helpful to keep in mind that we are talking about two different kinds of information. Number one, ordinary information, that is the content that is actually protected by the DRM technology, such as weather or fisheries data. And second, technical information with circumvention potential, such as cryptographic system or computer security information For the former, if DRM restrictions apply, circumvention is either prohibited for access control or impossible as a practical matter for most people. For the later, there is very limited standing. For the later, there is very limited standing exceptions. It seems that they can be invoked only by the person who actually does the initial act of circumvention. And the scope of dissemination of that information is quite limited. Further, some technical investigations will require permissions of or sole use by the right holders. Second, does Felton mean that there is nonetheless a zone of safety for academic computer science researcher? We are talking about Felton's case. Some have argued that Felton was never really in any danger of being sued, and therefore that other academic researchers are in no danger. I certainly agree with the author who agrees with Justin, whose comments that RIAA's initial threat to sue Felton, though that no future threats remain. Academic researcher still must determine when an academic research paper containing technical information with circumvention potential is also a prohibited technology. If a research paper contains computer code, as many such papers do, I do not think that the language of the statute would clarify exempted. For that reason, I think there is certainly a residual chill that applies to those researchers who want to put code on their papers. Some notable foreign computer scientists filed declarations in the Alcom case saying that they would no longer attend conferences in the United States because they were afraid of being arrested. Some of that was theater evaluation of threats, however, is partly subjective. If people say they are afraid, the fact that a well-trained copyright lawyer might conclude that their fears are boundless may in some cases be beside the point. Third, Third is worth noting separately that the DMCA is profoundly hostile to the open source software community, focusing on the language of the reverse engineering, encryption research, and computer security testing exceptions makes that crystal clear. The way that collaborations work within open source communities is that researchers put information they have learned on the web or on discussion lists and invite anybody who is interested on the web for or on discussion lists and invite anybody who is interested to help with the project at hand. Such widespread sharing of information does not seem to fall within the kind of behavior contemplated by the exceptions. The exceptions direct courts to consider whether the information is disseminated to others in a manner calculated to further research or alternatively in a manner calculated to further infringement. So this has been the basic test whether the knowledge or information shared is for research purposes or that is infringement, that is furthering infringement. I think it is going to be very hard to argue that sharing information about cryptography, research, or reverse engineering with the open source community as a whole, which includes anybody who wants to join it, satisfies that condition. In addition, the encryption research exception includes a credentialing provision which directs the courts to consider whether the person claiming the exceptions is employed or engaged in a legitimate source of study in computer science. The computer science research community is far broader than that, and this wording seems clearly to privilege a certain kind of scientific elite over others who might want to tinker with and improve software and enhance over understanding of programming techniques. I think we all understand that is not the way, and scientific progress historically has worked in everywhere. That's why we are having the advanced version of computers, advanced version of devices. So our scientific tradition includes many people who invented pretty cool stuff in their garage. The encryption research exception seems to contemplate a very different sort of regime. Very different sort of regime. Finally, it is important to reconsider the potential effects of DRM system and standards. To recall once again that the universe of scientific and technical innovation is a very complex system that exhibits a lot of path dependencies. A lot of dependencies. One cannot just drop DRM technology into the world of computer software and networking and expect nothing else to happen. We need to consider the effect these standards are going to have, both as initially implemented in discrete areas of the system and as they start to migrate deeper into the network. An initial class of network effects relates to the modification of other standards and technologies to increase their interoperability with DRM systems and increase the efficacy of larger DRM DMCA system. All consumer electronics equipment and blank media will have to be made interoperable with these technologies. Manufacturers who decline to comply with DRM standards may be shut out of content market. Manufacturers who design their equipment and media to override or ignore DRM standards may be vulnerable to charge that they have created circumvention tool. This has implications for researchers, even if you think that the most egregious instantiations of DRM will apply only to such things as music files and video games. Quite possibly, the same blank media that researchers want to use to write their research paper will be included with DRM protections at the behest of copyright owners who simply want to make it more difficult to copy music. In other words, the standards do not have to penetrate all the way into markets for data in order to have an effect on the conduct of research and innovation. What happens if DRM standards do gradually extended into markets, or if the migrate even deeper into the various technical layers of computers and computing networks. Some people who are developing DRM system have realized that they are relatively easy to circumvent if they implemented in particular applications or peripheral devices, and that they would be harder to circumvent if embedded in computer operating system, and even harder to circumvent if one could wire them into hardware or embedded them in the basic internet protocol. More widespread extension of DRM regime will reshape the ways in which information storage, retrieval, and exchange are handled. Earlier, the question of who will develop search tools that can interact with the individual DRM system, we now can extend this point to network searches more generally. We now, if one needs to license to develop a search engine, what kind of consequences will that have for the development of innovative search technologies? If archiving and storage become proprietary activities, will the risk of format obsolescence increase? Maybe not, do not have enough data to answer these questions. It is certainly a change from the way the development of search tools has worked so far. If DRM functionally continues to migrate deeper into the computing layer, we also may see decreased penetration of open source system, simply because it is going to be difficult to legally to create the kinds of interoperability that are necessary for open source systems to attain greater market share. In the pre-DMCA world, if consumers wanted their DVD players or their word processing programs to have behave in certain way, the open source community could do that relatively easy. If members of that community wanted to make it happen, they would. But if the information about how to make these systems interoperative with other components of the computing platform is protected under the DMCA, achieving interoperability will be much more difficult. In general, we can say with regard to relevancy of open source, so open source has been a great contribution for research, because the material which is available on the open source can be the impetus behind creation of new things. In conclusion, we can say that it is usually easy to convince academics and researchers that the worst case potential consequences of a phenomena are worth studying more closely. Yet the worst case consequences of DRM regimes and the protection given them under the DLCA are worth more than further study. The culture of scientific research is in some ways extraordinarily robust, but in other ways it is extraordinarily fragile. In particular, it is premised on a series of assumptions about the public domain and about access to and use and sharing of information that may soon warrant serious revisions. So we should understand the existing laws with a viewpoint of the prevalent situation, online, offline, the use of data, the use of material available should be done with permitted limits only. For example, for a researcher, what is required? He is required to take the data and present it, use it in his research with proper acknowledgements. There can be situations where restrictions by putting encryption, by putting other ways on these can be done, but a researcher must always base on his rights under the existing laws. For example, the fair use provisions. He should not go beyond the fair use provisions. Fair use provisions can be helpful for him. Either they are existing in the copyright, or likewise we have certain exceptions in the foreign laws also. So with this, I conclude myself, and I would like to end here with regard to the topic given to. Over to Dr. Hina Khan.
Open your camera. Thank you, sir. Thank you so much for your enlightening lecture. Now, on behalf of all the faculty of law, I would like to extend our great heartful gratitude for your engaging lecture, your insight into the topic were both enlightening and inspiring for our students and faculty as well. Thank you so much, sir.
Thank you, ma'am.